Well, hello and welcome everyone, and thank you for attending this Lunch and Learn put on by the Law Society of Nunavut. Special thank you to Marilee Rasmussen, who will be presenting today on common law powers of attorney. I'm Rebecca Jaremko, and I, together with Santana Stahlberg, am facilitating and coordinating the CLE put on by the Law Society of Nunavut. So as our fall offerings ramp up a bit, I encourage you to look on our website and see what else is offered. And Marilee, I won't take too much of your time. So suffice to say, we're very grateful to have you here. Thank you for presenting on this important topic, and I will turn the floor over to you.
Okay, thanks a lot, Rebecca. It's always kind of odd to do these things virtually, so please excuse me for all the mistakes I'm likely to make. And maybe just a little bit about me. I have been a member of the Law Society of Nunavut for just about 20 years. It's hard to believe. But that, time does have that way of passing by when you don't even notice. And for the last 8 years, I have been providing legal advice to the public guardian and public trustee, which is now in effect, a combined office in practical terms. However, I'm not the public guardian and public trustee. I just wanted to make that clear. As I've said to others, I'm just the lawyer. And what sort of got me thinking about this particular topic was the presentation that John McLean made back in April of this year about consent and capacity in the context of consenting to medical treatment. And he made the passing comment that there are no personal care powers of attorney that are legislated in Nunavut. And I think he also said that there was no particular provisions in legislation relating to advanced healthcare directives. That made me think about the issue of powers of attorney, and powers of attorney do exist at common law. And so let's just leap in to talk about that. I do want to say, if anybody has any questions, feel free to interrupt me, but there's likely going to be time at the end as well. So just in general terms, I thought that I would talk about these particular topics. First of all, what is a power of attorney? Then I wanted to look at the law reform initiatives in this country and other parts of the Commonwealth in the 1970s. Then look to Nunavut's legislation relating to powers of attorney, and some thoughts about the future. So what is the power of attorney? It's sort of elementary, but when you think about it, it's important to appreciate that a power of attorney is giving away power from one person to another. And so the document that is the power of attorney allows the person who grants the attorney or the grantor to give authority to another person to act in their place. So that other person is called the attorney, but don't be fooled by that word. The term attorney doesn't mean that the holder of the authority has to be a lawyer. The term comes from the idea that the person who acts for the grantor attorns to the principal in the sense of being responsible to the grantor. Now, attorning to the principal is also a strange, very specifically legal notion that wouldn't be, I don't think, understood by the average person, or perhaps even by the average lawyer. It's certainly something that I had to look up. But the idea is that this is in effect a type of contract where authority is provided by one person to another to act in that first person's place. I understand that powers of attorney of this kind have been in existence for literally thousands of years. And the scope of a power of attorney can be broad or it can be narrow. It confers on the attorney the power to do anything that the grantor could lawfully do, and it could be general or specific. Obviously, a specific power would limit the attorney's power to what is specifically listed in the power. For example, a power to sell or purchase real property. This is the sort of thing that I've come across in my practice occasionally when people are purchasing or selling property and they, for whatever reason, are not going to be physically located in the right place at the right time. And so they grant the power to some other person to be able to execute the necessary documents in order to have that process proceed. And I think in many jurisdictions, there's probably very specific documents that are required to be able to grant a power to deal with real property in that fashion. Not necessarily the case in terms of other specific powers. Whoops, see, there I go. My computer has a mind of its own. And a power of attorney can come into effect when it is signed, or it can come into effect on the happening of a specific event. And if it's tied to the happening of an event, it's called a springing power. Again, in my practice, in terms of estate planning, of course, a power of attorney features in that sort of context all of the time. And it's difficult to devise a springing power of attorney that will be, in a practical sense, easily invoked when it becomes necessary. For example, I think most people, when they're looking at actually signing a power of attorney, are really trying to provide a general power to do whatever needs to be done if they don't have the capacity to do that thing anymore, or if they are unable in a temporary sense to be able to do things like pay the bills because they're in the hospital, that sort of thing. But what I advise people in relation to powers of attorney is if you're concerned about whether you can trust the individual that you want to appoint as your attorney to use the document appropriately and in accordance with what you would wish, then you might have a problem with the person you've chosen to act as your attorney. If you can't trust them to use the document appropriately, then they shouldn't be appointed. And for that reason, I often advise clients that it's not necessary to have a springing power where you would have to have a whole process about how that power would be invoked, especially with respect to things like loss of capacity. And frequently what I do is hold the original power until the point in time when it becomes necessary to use it. And of course, a power of attorney creates fiduciary obligations. There's a fiduciary duty that imposed on the attorney and obligates the attorney to act strictly in the interests of the grantor. And the grantor can hold the attorney to account. That is, as long as the grantor has the ability to do so. And this again raises the issue of capacity. So capacity can only be granted by a person who is an adult, or sorry, not capacity. A power of attorney can only be granted by an adult who has capacity to act in that regard. The difficulty is that in the context of powers of attorney, there is no clear-cut test of what capacity involves. And given that the power is effective only if the grantor had the capacity to do the acts that are authorized in the document at the time that the power is executed, it follows that if the grantor lacks capacity to make an informed decision, for example, about a sale of the grantor's real property, a grant of power to make a decision of that kind to an attorney is invalid. And therefore, as well, it follows that if the grantor has a general loss of capacity, the power of attorney is invalid, with the caveat that third parties may or may not be affected. And that depends on whether or not the third party is aware of the loss of capacity by the principal or the grantor. And this is the situation at common law. So at common law, one can grant authority to somebody else to act on your behalf. But if you lose capacity, then that grant of authority is now invalid. And there's very little judicial consideration of this issue that I was able to find. I confess I haven't done exhaustive research, but it looks like probably the most recent decision taking these issues into account is the decision I've noted there, which is called Re Parks and is the 1957 decision of the New Brunswick Court of Appeal. I did find I think it was a 2001 decision in, I believe it was British Columbia, that referred to that decision as an authority. So it seems like it still holds some sway. And what that decision establishes is that a loss of capacity by the grantor means that the power of attorney becomes invalid at common law. So one can understand why this became an issue in the 70s with law reform commissions across Canada and the Commonwealth. The very time when a person is likely to want to have a power of attorney actually be in place is a time when the common law says it no longer exists. And the various law reform commissions in Canada, in particular, the Ontario Law Reform Commission in 1972 did a report on the issue of powers of attorney. I always love looking at law reform commission reports because they give you all that lovely history and analysis of the issues in a form that is completely reliable. And reliable sources, I guess these days, are more and more difficult to obtain. But the Ontario Law Reform Commission made that point that when the rule was being sort of firmly established that subsequent insanity, and I put the word in quotation marks, but insanity was the word that was used, that if the grantor became insane, that would revoke the attorney's authority. But at that time, the definition of insanity was clear-cut, and it was established or evidenced by the virtue of a certificate declaring a person to be insane. And the issue today is, and starting to, being observed in the 1970s, was that whether a person has capacity is a much more complex and nuanced kind of question. And we see that development of that idea in the context of guardianship legislation, which of course is near and dear to my heart, and the manner in which that legislation has moved away from the all or nothing kind of you're either totally incapacitated and therefore we grant a guardian authority over you in respect of any possible decision making, to the kinds of co-decision making regimes we see in various jurisdictions across the country. And I'll talk more about Nunavut's legislation in a minute as well. A couple of years later, the Manitoba Law Reform Commission in 1974 took up the issue of powers of attorney as well, and identified 4 major concerns. That first one, as identified in Ontario, that in the absence of a certification that a person is totally lost capacity, what capacity do they have and what powers can they grant? And the issue around this question is made worse or exacerbated by the fact that there's a stigma, and there still is a stigma associated with formally labeling a person as lacking capacity, whether it be, lacking capacity in certain respects or completely. The third issue that Manitoba identified was that at the very moment that a power of attorney is desirable to have in place, it is revoked by operation of law. And then the position of the attorney, who might be wishing to continue to act in the best interest of that individual who has lost capacity, it has become legally vulnerable. So these were all the issues that law reform commissions were struggling with and trying to analyze and make recommendations to governments about what to do in terms of legislation to address these various concerns. And I think there was an initial kind of round of reform that followed shortly after those Law Reform Commission reports. The Uniform Law Conference of Canada adopted a Uniform Powers of Attorney Act in 1978. I don't know if everybody listening is aware of the Uniform Law Conference. This is also another source of good analysis of legislation. It's a conference that has existed since 1918. When I drafted legislation on behalf of the province of Saskatchewan for a number of years earlier in my career, I attended the meetings of this conference, which is a meeting of drafters from across the country, from the various jurisdictions, who meet annually and who not just trades information and ideas about legislative drafting, but also work on developing uniform laws for enactment by provinces and territories, because of course there are some very significant issues that fall within provincial territorial jurisdiction, and therefore can and do vary from one jurisdiction to another in situations when it might be useful and expected by members of the public that the law would be the same regardless of the fact that you crossed a boundary. And, so for example, if I'm driving from Saskatchewan to Manitoba, I don't want to be expected to learn a brand new code of rules of the road. If I'm moving from one jurisdiction to another in Canada, I want my will to continue to be valid. And similarly, with something like powers of attorney, that it's preferable and in the public interest that these rules about these documents be the same as much as possible from one jurisdiction to another. And so the Uniform Law Conference put together a recommended Uniform Powers of Attorney Act, as noted, in 1978. And of course, the adoption of a uniform act by the conference doesn't make it the law anywhere. It has to be actually enacted in the legislatures of the various jurisdictions across the country. The Uniform Act was further revised and replaced by what is now called the Enduring Powers of Attorney Act, which was adopted in 2015. And many jurisdictions in Canada have enacted legislation relating to what is now called co-decision making, and have enacted legislation relating to enduring powers of attorney. And in Nunavut, the legislation, the Nunavut Powers of Attorney Act, was enacted in 2005, as you see there from that notation. And therefore, it was enacted prior to the adoption by the Uniform Law Conference of the Enduring Powers of Attorney Act. And that's one of the issues that I wanted to talk about. So in the Nunavut Act, there's a definition of power of attorney, and you see it there. A power of attorney means the power of attorney described in subsection 2(1), and includes both an enduring power and a springing power. And of course, the issue is the definition in 2(1), which describes a power of attorney as being one, as you can see in Clause A in particular, that is given by a donor with respect to the donor's property and financial interests, and is executed. It doesn't matter when it was executed, whether it was before or after the act came into force in 2005, with some exceptions, as are noted below, that aren't really particularly relevant to this conversation. But the important point is that a power of attorney under this act includes only a power of attorney that relates to property and financial interests. And it's only that kind of power of attorney that, by virtue of Section 8 of the Act, can be made enduring. So a donor may provide in a power of attorney that it is to continue despite any mental incapacity of the donor that occurs after the execution of the power of attorney. And of course, after is important. The donor has to have capacity at the time that they execute the power. But if they cease to have capacity, they can say in the power of attorney that it would endure or continue despite their lack of capacity in the future. And if it's a property and financial power, it will then be able to continue. There's also provision in the Act, and I didn't include that in the PowerPoint, but there's a section in the Act that talks about being able to file a power of attorney, an enduring power of attorney with the public trustee. And I mentioned from the outset that the public guardian and the public trustee is now one office. And that is a relatively recent development. The public guardian and public trustee have had a combined office since I think it was April 1st, 2020. But the legislation wasn't really changed. What has happened is the public guardian is appointed under the Guardianship and Trusteeship Act. The public trustee is appointed under the Public Trustee Act. And what has happened is the same individual has been appointed to both of those offices. And the office is now physically located, the two offices that were separately located are now physically located in the same premises. So that makes me think about the issue of personal decision-making. And as I mentioned, I have been working on behalf of the Office of the Public Guardian in particular since 2016, and for the public trustee from time to time prior to 2020, and since that time more frequently. And I think I would say that of the approximately, I would say there's about 275 or so guardianship orders in place, and the number of trusteeship orders in place is significantly fewer than that. I don't know the precise numbers, but I would be surprised if it was more than 20. So just to recap this, the power of attorney that deals with financial matters or property matters can endure. The power of attorney that deals with personal matters cannot. And the guardianship applications that occur, generally speaking, in Nunavut that I've been involved with, kind of fall into three categories or types of situations. There's persons who have capacity challenges from birth. They've never had capacity. This would be a person who would never have been able to provide a power of attorney in any event. There's persons who experience a decline in capacity due to addictions or injury, and depending on age, they may have been an adult with capacity at some point before that decline in capacity occurred. And then there's persons who lose capacity over time due to age-related declines, such as dementia and Alzheimer's and other related kinds of medical conditions. And these are individuals who would have had capacity as adults, but as mentioned, have lost it over time. I don't have precise numbers about how people, or what categories these people would fall into, but my impression is that perhaps as many as 50% of guardianship applications could be avoided if an enduring power of attorney was in place for personal decision-making. And so, where does that take us? Capacity we now regard as being on a continuum. It's not necessarily all or nothing. I might not be able to make a decision, fully comprehending the nature of activities relating to complex financial transactions, but I can decide who I want to spend my time with or where I want to live. And, those are the kinds of personal decision-making choices that in many respects are even more closely connected to personal dignity. And ones that and that kind of capacity is one that we need to protect and respect for as long as that's possible. The existing guardianship legislation does recognize the fact that capacity is not necessarily all or nothing. And it does require that there be a demonstration of a loss of capacity with respect to a number of discrete areas of decision-making. You know, maybe I'm not able to make decisions about medical matters. You know, maybe I need assistance in that regard. Mind you, I use that phrase and I want to put an asterisk beside it. Let me come back to that. That maybe I can't make those decisions by myself, but I can make those decisions about, for example, as I mentioned, where I want to live or who I want to spend my time with, or you know, what I want to eat. These are all really fundamental personal decisions that in guardianship contexts can be handed over to a guardian to make those decisions on behalf of an individual whose capacity is compromised. And it's also important to pay attention to the Nunavut legislation, which relating to guardianship, which defines a loss of capacity as being one where you're not able by yourself or with assistance either to appreciate the information that's necessary to take into account in making a decision, or that you're not able by yourself or with assistance to understand the consequences of making a decision in any specific area. So the with assistance, I don't think is necessarily found in other guardianship legislation across the country. I don't believe that, for example, is in Saskatchewan's legislation, which is the jurisdiction where I live. And I think that's an important consideration, because while Nunavut doesn't use the phrase, you know, co-decision making in its legislation, in effect, that's what the Guardianship Act does create. Guardianship and Trusteeship Act in Nunavut does create. First of all, by requiring that you can't get an order if a person is able with assistance to make the decision. But secondly, even if a guardian is appointed with authority to make decisions on a range of issues relating to personal matters, the guardian is required to involve the person in the decision-making to the extent that that's possible. The guardian, I think it's section 12 of the Guardianship and Trusteeship Act, talks at great length about the requirement that the guardian basically discuss the possible decisions with the individual who's under the guardianship order, that involve them in the decision-making as much as they can, to engage with family and friends who are close to the person, to ensure that consultation occurs and that these decisions are made appropriately on behalf of an individual where they're not able to make them on their own behalf. And a power of attorney is one mechanism that allows an individual to retain control over decision-making, even if they lose capacity over time. And whether we call it a power of attorney or, as I say, co-decision making, I don't think the terminology matters. It's that we need to recognize that just because there is some decline in capacity doesn't mean that the person now needs to be totally, to have all their rights to make their own decisions about their life totally removed from them. So, you know, it seems to me that a kind of easy change would be to amend the current Nunavut Act to have it apply not just to financial and property powers, but also to personal decision-making. Now, I do recognize that there are, as I put it here in the slide, big issues to take into account in developing legislation to protect those who are the most vulnerable among us. And these issues are complex. You know, I don't mean to sort of trivialize the situation. They're complex, they're complicated, and you see all of this discussion in the various reports from law reform commissions that I referred to earlier, as well as the reports prepared within the context of the Uniform Law Conference, another good resource for information about the kinds of issues that lead to the Uniform Acts that are adopted and that are available on the Uniform Law Conference's website. But I think that we shouldn't let pursuit of perfection get in the way of improvement, that there are incremental steps that could be taken. And that, one small step would be to include the personal power of attorney within the definition of powers of attorney to which the Nunavut Act now relates. And that would then permit personal decision-making powers of attorney to be enduring powers so that they could exist and continue to be legally valid after a person loses capacity or in the course of their decline with respect to various issues that may arise. I think the importance of this is that it would then make unnecessary many applications to court. And I think I would say that particularly in Nunavut, individuals are not keen to find themselves in court. I don't think that there's a general understanding that the guardianship process is not typically an adversarial process. It's not a question of winning or losing a guardianship order. It's a question of finding what is the right thing to do for the individual who may need some assistance in decision-making with respect to these various matters. But in spite of that, people are averse to participating in court proceedings. And, I note, for example, that one of the parties that has to be served with guardianship application documents in every case is the person described under the legislation as the nearest relative. It's rare for a nearest relative to participate in these proceedings. And I suspect that it's because, going to court is not considered to be a very positive experience. So if the power of attorney legislation could be amended to allow those personal powers to endure, there would be the ability for individuals to say, if anything happens to me, perhaps I'm aware of the fact that my family history is maybe not great. I may think that it's a good chance that I could lose capacity over time. I want to make sure that the person who makes decisions for me when that happens is somebody that I choose, not somebody that a court that I, perhaps not totally confident in makes. And I say that not being critical of the courts. I know that they do a very good job and they're very conscientious about the orders that they make. I know that these are difficult decisions for the courts as well. And it would be better for all of us if we were able to say, yes, this is the person I want to make decisions for me, if anything should happen that makes it not possible for me to make them on my own. And I would encourage legal counsel, where it's possible, to adopt a practice of advising clients to enter into powers of attorney with respect to personal matters, in spite of the fact that the legislation may not be amended. I am quite confident that even without legislation saying that a personal power is an enduring power, that if there were such a power of attorney that a person had adopted while they had capacity, and now we're having to make a guardianship application to have a guardian appointed for them, that power would be a very persuasive document to provide to the court about what the wishes of the individual were. And I'm sure that unless there were extraordinary circumstances that would dictate otherwise, that the court would be wishing to appoint the individual named in that power. So it would make the eventual guardianship application to be a more straightforward process, if I could put it. And that's what I think that we might be able to do in practical terms to promote the ability of the individual to say in advance who they wish to help them to make their decisions when they no longer can, is to encourage individuals to make those decisions while they're competent, and name in a formal way the individual that they would want to carry out that authority for them and on their behalf. And so that takes me to questions, and I hope you have some. I could maybe also suggest that this is the teaser for another presentation that I've agreed to provide on behalf of the Law Society, and that relates more specifically to the guardianship, the application for guardianship process under the Guardianship and Trusteeship Act, which I think is scheduled for this time next week. Oops, I see something in the chat. Ah, yes, right. Keisha says, thank you. It would be interesting to see the effect of the new Mental Health Act once enforced, specifically the role of the selected representative. I won't embarrass myself by trying to pronounce that, for persons requiring care under the MHA. And yes, I know that the Mental Health Act has been revised, and along the lines I think that I'm suggesting would be appropriate for revision of the guardianship legislation. I mean, ideally, we would have a continuum of legislation that it would involve guardianship, what can be called a power of attorney, or co-decision making or substitute decision making, to have that, that whole continuum of processes revised, and all of this legislation redone in a more sort of comprehensive and holistic fashion. But I also know that that's a huge task, which is why looking for practical solutions that can be implemented more immediately, I would hope to persuade people that they could enter into a power of attorney relating to personal matters that could be utilized if a guardianship application became necessary. And there's another interesting feature of the act with respect, the current Powers of Attorney Act with respect to financial matters, and that is that it provides an opportunity for a financial power to be filed with the public trustee. And I think that also would be a very useful process, that if all of those powers of attorney were filed with either the public guardian or the public trustee, depending on what they relate to, or even if a power of attorney relating to both financial and personal matters is filed with that office, that can be also a very useful mechanism for ensuring that individuals' wishes are respected. Well, maybe everybody is very hungry and wants to get to their lunch. Or I hope that the fact that there are not a lot of questions might mean that I've provided an explanation with some clarity, and I hope that it has some influence, or will make you think in future about this kind of issue and the related issues concerning guardianship that we'll talk about next week. So Rebecca, is this perhaps an appropriate time to sign off a little early?
Thank you so much, Marilee. That was a great topic, and we appreciate you taking the time to speak with everybody today on this Lunch and Learn. So if there's no additional questions, we will end here. And if there is anything, please feel free to reach out to us here at the Law Society, and we can pass along any questions to Marilee as well.
Yeah, for sure. I don't mind any questions as you think of them in the future. If you're like me, you'll think of them later. And please do send them on. I would be happy to respond.